question is only this: why 2 months out of 3 years? Labor law, they lay off people because if you complete 365 days in a year, you're deemed to be a regular employee. Mr. Ganguly, your argument falls then. 90% of the authorized strength, you're way below the authorized strength. Somebody who comes in at 18 continues till the age of 60. Now, and you lay him off every 3 years for 2 months. Either you pay them salary for 2 months and lay them off. Give them salary. Their whole problem is they can't take up any employment.
मध्य प्रदेश होमगार्ड नियम 2016 के नियम 27 गा के प्रावधान के अनुसार दिनांक 13 अप्रैल 2016 के पश्चात नियुक्त सैनिकों का वर्ष में 2 माह बाध्य कॉल ऑफ किया जाकर 10 माह की ड्यूटी पर रखा जा रहा है एवं मुख्य सचिव की अध्यक्षता में संपन्न बैठक दिनांक 23/10/19 के अनुसार दिनांक 13 अप्रैल 2016 के पूर्व नामांकित होमगार्ड का बाध्य कॉल ऑफ 3 वर्ष में 2 माह किया जा रहा है। इस प्रकार एक ही बल में बाध्य कॉल ऑफ के 2 नियम प्रचलन में होने से विसंगतिपूर्ण हैं। अतः बैठक में निर्णय लिए के अनुसार मध्य प्रदेश होमगार्ड नियम 16 में संशोधन कर सभी होमगार्ड सैनिकों का कॉल ऑफ 3 वर्ष में 2 माह किए जाने की एक रूपता लाए जाने हेतु गृह विभाग मंत्री परिषद संक्षेपिका वित्त विभाग की अनुमति कर समकेक्षा को मंत्री परिषद के समक्ष स्वीकृति हेतु भेजा जाए। So, my lord, what has happened, my lord? In 2015, approximately 3,000 homeguards have been inducted, my lord. When in Ujjain there was a big Srestha Mela was organized. Now, at that time, my lord, the persons those who have been recruited in 2015 for 400 days, my lord, as a homeguard sainik, my lord, their services have been dispensed with. And when 2016 rules came, my lord, they protested the issue before the authorities, and ultimately the decision was taken to take them as a homeguard sainik. So there is a disparity, my lord. Those 2,500 to 3,000 persons are having governed by the separate rules of 10 months and 2 months call off, my lord. And earlier persons, those who have been recruited prior to the year 2016, my lord, they have 3 years at 2 months, my lord, call off period. So, my lord, to maintain parity, my lord, this decision was taken so that the entire homeguard services, my lord, all the persons should be treated under the one roof, my lord. So this decision was there. My lord, my submission before your lordship is that, my lord, if your lordship permit me 10 minutes time, my lord, then I will just like to show 2-3 things, my lord, and the judgment of Honorable Justice Single Bench, my lord, wherein certain paragraphs which have been read over earlier, my lord, I would like to read further few paragraphs, my lord, which clearly indicates that now there is absolutely no scope with regard to argument of civil post holder. There is absolutely no scope with regard to grant of regularization. There is absolutely no scope with regard to pay fixation or parity as they have been claimed. So, my lord, if your lordship permit, my lord, then I will read few paragraphs of that judgment, my lord.
Before you come to the judgment, show us this note completely as to what is the view of the finance department and the other.
My lord, that finance department, my lord.
You're saying there is a financial burden.
Yes, sir. That financial that in the Pressy, my lord, it is at in this compilation, it is at page number 8. My lord, now there is absolutely no disparity, no discrimination. Otherwise, there was 2 sets of employees, my lord. Those who are governed by 2016 rules, my lord, they are having 10 months call off and 2 months break, my lord. And earlier nominated persons have 3 years, 2 months. So now there is an exile decision, my lord. That is. Yes, my lord. Now, my lord, may kindly have a look.
How were they? What was the process of recruiting?
My lord, what has happened, my lord? After the 2016, my lord, the basic grievance which have been raised in the earlier round of litigation is that there is absolutely no procedure, no rules, no salary, and the authorities are trying to victimize these persons, my lord. That is para 3 and para 4 of the judgment passed by the single bench. So the Honorable Court at that point of time has also considered the recommendations made by the Human Rights Commission, although the single bench has of the view that in terms of the judgment of the Honorable Supreme Court, the recommendation of the Human Rights Commission cannot be implemented or no mandamus can be issued. But still, the Honorable Court has directed that the recommendation of the Human Rights Commission may be considered by the expert committee. Now, that matter traveled up to Honorable Apex Court, my lord. The Honorable Apex Court has directed us to frame the rules, my lord, with regard to determination of service condition. Now, as per this 2016 rules, my lord, the person who is willing to apply and to opt for the homeguard services, my lord, as per his own will. The wording starts that if he is willing. So, my lord, if anybody is willing, my lord, then he has to approach to the authority. There is a layer of selection committee, my lord. which scrutinizes his candidature, my lord, and thereafter, after the appointment of these persons, my lord, and undergoing with their training, now they have to work for 3 years, wherein 90 days leave has been prescribed. There is a salary of 29,140.
Mr. Ganguly, that is not the question. Are there regular sanctioned posts
My lord, for
in
Homeguard,
Homeguard?
my lord, in Homeguard, there is a sanction post of 16,000.
For recruiting to that post, now you've discontinued recruitment. You're not recruiting anymore.
No, my lord, now in near future, my lord, since in 28, my lord, we are again holding the Sinhast in Ujjain, my lord. So there are possibility, my lord, that looking to the preambulance of the act, my lord, the state government may further recruit 4,000, 5,000 persons, my lord. So it's a volunteer service, my lord. The state government can always take a decision.
What was the mode of recruitment in the past? Did you take out an advertisement, invite people? Did they go through a competitive process?
No, my lord, no, my lord.
What was the mode of it?
They have to apply to the committee, my lord. The committee scrutinizes their candidature, my lord, and on the basis of the scrutiny of the candidature, my lord, the person is being sent to training, and after completion
What
of
is the scrutiny means what?
after 2016, my lord, it is my humble submission is that no recruitment was taken place.
That we are conscious because these are all people pre-2016.
Pre-2016.
So what was the mode of their, did they undergo a selection process?
My lord, they have
Or
undergone with the test.
You can go to anybody, give an application, you're recruited without
No,
any.
but they have gone through with an aptitude test followed by their training and scrutiny of records.
So they have all been recruited through a recruitment process on sanctioned posts.
Yes,
Yes.
for Homeguard volunteer.
We're not on the volunteer aspect. We had a lot of discussion on that last time.
Yes, sir.
So recruitment process, there was a recruitment process followed, whether it was just an interview or what, there was a criteria also prescribed. Was it an open advertisement? What was the position?
But they have all willing persons can apply.
There was an open advertisement.
On the basis of advertisement, a person can always apply. Yes, sir.
It was an open advertisement.
Yes, sir. The person,
Anybody could apply, but was there a qualification prescribed, age limit and things?
Yes, sir. That
Age
is
is
there.
there, my
That
lord.
is there.
Age
That
is
is
there.
there. That is there.
Age is there, my lord.
What page is the?
18 or 19 years he has to be.
But reference number 2, my lord.
That is the
it is
basic, my lord.
now
Mr. Ganguly. Question is only this, why 2 months out of 3 years? Why not
Malad,
0 day?
Malad,
Why not 6 months?
Malad, just your lordship may give me 5 minutes, Malad, that what has already been decided, Malad, by this honorable court. Just Malad, may bear me with me, Malad, for 5 minutes, Malad.
Yes.
Now, Malad, may kindly come to para 7, Malad.
You see,
Para 7.
once again, Mr. Ganguly, another thing. The scope of inquiry in this writ petition is not their regularization, not absorption.
No, neither civil post holder.
They are only challenging, why are you laying us off for 2 months and 3 years? Assuming we were to allow the petition and say there can be no layoff, there can be no call of duty. Whatever is the consequence of that will ultimately follow. Whether they are treated as regular employees or not, that's not the challenge here.
Malad,
So you've still not given us the rationale. Why only 2 months? Why not 1 month? Why not 3 months? Why not 6 months?
Malad, may kindly appreciate. Just 1 minute, Malad. What has happened, Malad? After the orders passed by the Honorable Supreme Court, Malad, in this matter, wherein the earlier finding that no mandamus can be issued for a civil post holder, no writ of mandamus can be issued for regularization. All these things have been held by the single bench, Malad, which has been affirmed up to the level of Honorable Supreme Court. The Honorable Supreme Court has just changed the date of grant of the minimum pay scale, which was initially directed as a interim measure, Malad. Ultimately, it was directed by the single bench, Malad, that the rules may be framed by the state government in accordance with law by observing the Human Rights Commission recommendation. Now, these rules, ultimately, after the directions of the Supreme Court, Malad, we have framed the rules. Now, they have challenged the validity of one of the particular clauses of the rule. Now, Malad, my submission to your lordships is that once the rule is being challenged before your lordships, Malad, then there are strict parameters to challenge the rules, Malad. First, whether the state government is competent or not. In the entire petition, Malad, they have not raised a single word, or even otherwise, Malad, they have rightly not raised the competence, Malad, because it is the Honorable Supreme Court wherein the list was finalized and the state government has framed the rules. Even otherwise, it is in the state list, Malad, so the state government is competent enough. Number 2, repugnancy, Malad, there is no argument at all, Malad, that this is repugnant to any act. Nothing. Third, Malad, arbitrariness, Malad, there is absolutely no foundation in the petition, Malad, that the rule in question is having an
rationale. everything ultimately then boils down to rational arbitrariness, everything comes in. We've still not understood why 2 months or why layoff at all.
My lord, what has happened, my lord?
Is it your case that in 36 months, 2 months we don't require?
My lord, what has happened, my lord? In the
If
original,
we were to pass an order, lawyers will not appear in court on Wednesdays. Rational? No rational? Nobody will appear on Wednesday? Or X category of lawyers will not appear on Wednesdays, X, Y category not appear on Thursdays. Has to be rational.
my lord, then it has to be.
You are taking work from them. Initially, you felt 2 months in 1 year we didn't require them.
Yes, ma'am.
Now you come up with 2 months in 3 years.
Yes, ma'am.
What is the rationale?
Now, my lord, in Homeguard Act and rules, my lord, there is also a provision, my lord, that in every 3 years, my lord, the volunteer homeguards, my lord, are required to recheck with certain parameters, my lord, like the integrity of service, my lord, which they have rendered for 3 years, the medical fitness. They are all
That
these.
is there in every force.
That is.
There is an annual appraisal, there is an annual fitness examination. We all undergo that. That still doesn't answer that 2 months. We're not able to fathom what is the reason. You see, in labor law, they lay off people because if you complete 365 days in a year, you're deemed to be a regular employee. It appears that that is the rationale behind this.
Well, that is one of the reasons, my lord. That
Then
maybe
please,
the one of.
then please spell it out and come forward and say so, because then the period is 365 days and they're not laborers. That labor legislation will not apply. And that is only for a period of 3 years, of 1 year, not 3 years. So if they work for 365 days, if that's the logic, then they're regular.
No, my lord,
So we are not testing what is the consequence of them working for 3 years in a row and or a break of artificial break of 2 months. That regularization, absorption, all that is not a subject matter of challenge nor the question of civil code. You've not given us in your reply or in your argument even the minutes that you've produced. What is the rationale of that 2 months? We can understand summer break. We have say cleaning staff in the court. And we say summer break there'll be no footfall, so we don't need parking attendants. Lay them off during summer break. Here there is no such thing.
my lord, if you'll not come up.
If there is no rationale, we'll say you can't have a layoff of 2 months.
My lord,
Whatever is the consequence.
my lord, my lord, my submission is that this is the discretion of the government, my lord.
Has to be reasonably
Huh.
exercised. What
My
is the
lord,
rationale?
my lord,
Give us a
if-
rationale, we may accept it.
My lord, the earlier trend in this matter may be kindly be seen, my lord, that from up to 1990, my lord, they have been deployed for 6 months, my lord. From 1990 up to 2010, it was 10 months. Then,
That's
so my lord, it is gradually increasing.
No.
So,
Issue is there somebody who's gone on record to say that we need their services only for 2 months in a year, 6 months in a year? For example, you're saying there is this something happening
And-
where you require 5,000 volunteers. We can understand, all right, we need 5,000 volunteers for 6 month period because we are having a mela or whatever. They'll be recruited for 6 months. After 6 months, you will say, sorry, now you please go because you were for 6 months. Here, there is nothing.
Lord, what has happened, my lord? The person, those who are being recruited for four months or 6 months or for a year, my lord, initially they recruited as an homeguard sainik, my lord, for a current period, my lord, but subsequently by raising their demands and which has been ultimately accepted by the state government from time to time, my lord, these persons have come under the umbrella of regular.
Understand this. No government will accept their request to increase unless they require them.
It's it.
Because it's a financial burden.
Yes, ma'am.
You won't say, I recruited you for 4 months, you requested, so let me continue for another 6 months. That won't. You will realize that yes, we need work it doesn't get over in 4 months, so we continue them. Here, on a perennial basis, you need work. You are taking work from them, but you are rotating so that there is an artificial break of 2 months in 3 years. That logic we've not understood.
Well, for that, well, my submission is that the competent authority in its discretion being a policy matter, my lord,
What
can.
policy matter has, it can't be, I have taken a policy decision to terminate all X kind of employees.
Yes, sir.
It can't be that's not a policy decision. You may say it's a policy, but it's not a policy decision. It's an arbitrary decision. What is the rationale of those 2 months? We can understand, you say, all right, in 3 year cycle, November and December, we will have no home guard
Yes, sir.
for whatever reason. No such thing.
My lord, if the harmonious construction of certain provisions are being seen, my lord, from the Homeguard rules 2016, my lord, then it can be easily infer, my lord, that there is a provision, my lord, wherein that is Rule 21, my lord, which deals that how the Homeguard persons can be deployed by the state government or the district commandant at that level. In which Rule 21(2) says, my lord, that total number of volunteer homeguards so called out shall not be less than 90% of the authorized strength of the district reserve force. Call out up to 100% can only be made with prior approval of the state government. So there are provisions under the rules itself, my lord, that even in 100% call off or the persons can be deployed under the rules, my lord. And for that, my lord, the state government is having the power, my lord. That 21(2) may be seen, my lord. But this is, my lord, it is in reference to, my lord, page number 9.
Page number 9 of what?
Rule 21(2).
What is the district reserve?
For district reserve, my lord, that in the Homeguard Sainiks are required, although across the Madhya Pradesh, my lord, but in every district, my lord, there is a sanction strength based upon the capacity of the city or the place, my lord. So, my lord, in every district, my lord, there is a sanction strength of 150, 200, 300, 500, 800, whatever is being provided in the sanction by the state government, my lord. Suppose in Jabalpur city, my lord, there is a 500 sanction strength, my lord. So up to 90% will call, and even in Jabalpur, 100% call can be made.
How do you reconcile call out of home guards and call off of 2 months?
My lord, normally, my lord, what has happened, my lord, this sanction strength is based upon.
Call out is only in particular circumstances.
Yes,
It's
my
not
lord.
on a regular day-to-day basis.
My lord, what has happened, my lord? Normally the sanction strength, my lord, for a city is being fixed with the aims and object of the act.
When did you stop recruitment? 2016?
In fact, my lord,
16.
prior to that.
All right. Even if we take it from 16 to now, 10% must have retired.
10% must have been.
So then 16th objective is achieved.
Then that's why I am saying, my lord, that's why 10 months in a year has been increased to.
Now 100%.
My submission is that if you lordship direct or the state government is of the view, my lord, then they can do it 100%, even without a court order. Even this is, my lord, my submission is that this is the analysis of the state government. It is the domain of the authorities, my lord, to act in accordance, to act in terms of the rules or the act of the spirit of the act or rules, my lord. So there is a discretion with the authority that they can call out 100% also, my lord. It is never known, my lord, that in the next year, my lord, it will be 36 out of 36, my lord. So it is the authority, my lord, it is the competent authority who, based upon this requirement or the looking to the perennial aspects of the matter, my lord, or the requirement of as available in different districts, my lord, can even call for 100%, my lord. So, my lord, my submission is that not only this, my lord, there are other conditions also, my lord, which postulates that the authorities, it's a voluntary force, my lord. The person can always opt for it, my lord. They can go for it, my lord. So there is no binding that under
every recruitment is a voluntary process. Whenever an advertisement is taken for any post, it's a voluntary process. In what you are arguing, that anybody can apply who qualified. Same here. If you take out an advertisement, whoever is qualified can apply. Of course, it is voluntary in that sense. It's no longer a voluntary service in the sense that when it started, that any serving government officer is all right, I volunteer for doing social service. That stage is over, but nonetheless, that is not a subject matter of challenge in this petition.
My submission is that if what I am saying, what is coming from your lordship, my lord, is exactly the para 7 of the order passed by the single bench, my lord. Exactly the same circumstances. My lord, may kindly have a look to para 7, my lord. Accordingly, in sum and substance, the grievance of all the petitioner in these cases are that the organization is functioning from last more than 50 years, even though it is initially started with voluntary organization, but with the passage of time, it lost its voluntary character. Instead, has become a regular establishment assisting the regular police force of the state, even though the petitioners even like the persons like the petitioners are required to perform regular duties, they are neither paid regular salary or pay scale or other service benefit. Inter alia, contending that no statutory rule or regulations have been framed and in an arbitrary manner the respondents are treating the petitioners as voluntary and denying them the statutory benefit, these petitions are filed. So, my lord, exactly, my lord, this is the argument raised in the earlier round of petition that after the passage of 50 years, now the character of voluntary nature has been lost its
Mr.
time.
Ganguly,
Yes, sir.
that is not the scope of inquiry of this case. We are not even considering that they should be declared as civil posts, they should be declared as regular employees. That's not the question. For example, in the first matter, from 1st February 2020 to 31st March 2020, you said he will not be called on duty. What is the rationale? Did you not have work between those 2 months?
My lord, what has happened, my lord? Now, I may be I may be permitted to simplify one thing, my lord. That what has happened, my lord, in every district, my lord, on the basis of a roster, my lord, so that everybody may get the equal opportunity, my lord, the duties are being allotted by the district commandant. So, my lord, there is a roster in every district. So, if a person is being recruited, or we have the force of 500 persons in a particular small district, my lord, wherein we are required to deploy 400 persons or 415 or 20 persons daily, my lord. There is a requirement. So, based upon that requirement, my lord, and the enrollment done in that particular districts, the rosters are being regularly prepared. So, if a roster is being prepared, and there is a rule itself, my lord, that all the home guards should be given equal opportunity while applying that particular roster. So while applying that particular roster, my lord, as per the statutory recruitment rules, 90% we can deploy. So the 20% persons, my lord, or the persons which are equal in number, my lord, they can put to rest for a period of 2 months, so that that particular remaining persons, those who are not being deployed due to 90% ratio, my lord, they can be adjusted.
Mr. Ganguly, from 2016, people are retiring. You are not hiring.
Yes, sir.
So this requirement which was existing in 2016, are you saying if you required, say, let's test your example, 10%, you had a strength of 500, so you're saying 10% we laid off in 2016. Today is that 500 strength would have come to 300. That means you still needed that 450 in 2016. In 2025, can you say you need less than 400 or less than 300? Condition of service.
Yes, sir.
Yes.
So 27C, which is alone challenge, my lord, if it is read with A and B, my lord, then there is a purpose also, my lord. That in 3 years, subject to your willingness, subject to your conduct, subject to your character verification, subject to your fitness, etc.
That is separate. You see, if you had kept it 10% of a year, it would have still be logical in terms of Rule 20.
It is there, my lord.
But 2 months in 3 years is not 10%.
My lord, my submission is that even 90% is mandatory, 100% subject to approval of the state. So now,
Let's assume
remaining 2 months, my lord, the state government, if is the opinion, my lord, that we required 100% manpower looking to the deficiency as existing today, my lord, then state government in 22 has amended it, my lord. In near future, it can amend also, my lord.
Mr. Ganguly, we have not seen any document or minutes produced by you to show this, that because of rule, you see ingenuous argument in court, record doesn't say Rule 22 requires 90% maximum in exceptional cases. Hence, we will only at a particular time maintain 90% of the force and rotate every 10%. Where is that decision? Not the working strength, authorized strength. Authorized strength, Mr. Ganguly, your argument falls then. 90% of the authorized strength, you are way below the authorized strength.
As on date, my lord, that's why, my lord, initial 10 months in a year has been changed to 3 years.
21-2, 90% of authorized strength. If it is logicist, we are keeping 90% on hold. 10% we rotate by call off. What is the authorized strength?
16. Because that rules accept.
How much is the working strength today?
Approximately 9 to 10.
No, no, you have 10%.
So that's below 90%. So everybody has to be called on duty. You have to call everybody on duty now.
Yes, my lord.
So that argument also goes.
Not only this, my lord, one point is there, my lord, section 27, what my learned friend is reading before this honorable court, my lord. That is very specific about the age also, my lord.
41 years.
27, that 41 years according to the rule 2016, my lord. Now it is 60, my lord. Now it is 60. A
That's all
person
right. That's all right. But
who is being appointed at the age of 18. Section 8 says very clearly, my lord. Section 8, my lord. Kindly come to that. No person shall be enrolled as a volunteer of Homeguard unless he has completed the age of 18 years, but has not completed the age of 28 years. That means a person who is below 18, he is not supposed to apply for the Homeguard, becoming the Homeguard signing pilot. But mandatory provision that 18 to 28 pilot. There's an age bar pilot. Then he can continue up to 41 years as per the rule 2016. Now that has
16.
been amended. Now he has to work for the age of at least for the 60 years.
And Mr. Ganguly, from somebody who comes in at 18, continues till the age of 60. Now, and you lay him off every 3 years for 2 months. Either you pay them salary for 2 months and lay them off. Give them salary. Their whole problem is they can't take up any employment. In that 2 months, nobody will employ them for 2 months.
There are conditions not in the rules.
Salary, no. During that 2 months, they can't take employment.
Yes, that is not, they cannot, my lord.
How are they going to
That's a
sustain?
binding,
Families-
that's a
families
condition.
to sustain? How do the families sustain? You expect somebody
How
to
they are
work from
surviving,
18 to-
that's a big question, my lord.
expect them to work from 18 to
Yes.
60. And 2 months you lay them off. You can't take an employment. We will not pay you.
No earning source, my lord, no earning source.
The entire concept is required to be viewed on the point that ultimately, my lord, their induction as a voluntary, they are being inducted as a voluntary member. Number two, that if a person is appointed under any government duty after following the due process of law or following the statutory rule, he is bound by the conduct rules. He is bound by various other limitations, my lord,
The rules,
wherein
particular rule, they are not saying don't take work from us. They are saying take work from us every day of the year.
Yes, we are ready.
You are saying 2 months I will not take work from you and I will not pay you. You can't get employment
That
somewhere.
is the first condition, my lord.
Not logical. Not logical. Unless you show us the reason, we've not still been able to see a reason. So we'll continue tomorrow, see what reason is there.
But I have
You
also
can
requested
find out from the file.
to consider the judgment of the
Pantha Chatterjee's, my lord.
voted into the Supreme Court.
This
It
is a
totally
very important.
converted by Maharashtra.
Everything is yes, my lord.
Everything is there.
We'll consider it.